We need to pass a resolution that the clock is off. Just saying.
Need a resolution for that?
New Year's resolution?
Welcome, folks. Welcome. This hearing with the New Britain Township Zoning Hearing Board is called to order. In preparation for our business this evening, I ask that everyone in attendance please silence your cell phones and place them in do not disturb mode. For your information, this, like all township meetings, is now being recorded and shared via virtual meeting, just so you know. A few additions, or I'm sorry, some introductions this evening. To my far right is Ryan Gaiman. He is our Assistant Zoning Officer. Followed by TJ Walsh. He is the council solicitor for the Zoning Hearing Board. Kathy Basili is a member of the Zoning Hearing Board. Scott Fisher, member of the Zoning Hearing Board. Sean Gresh is a solicitor for the township, and our stenographer this evening is Lisa. And your last name, Lisa? Drumheither. Love it. Excellent. Welcome. My name is Chuck Hoxhead. I'll be chairing the meeting this evening. So a little bit of housekeeping for the record. The New Britain Township Zoning Hearing Board is a quasi-judicial body required by the statute of the Commonwealth of Pennsylvania and created by the New Britain Township Board of Supervisors. This board is chartered with a single responsibility to provide due process to the citizens of New Britain Township to appeal zoning and engineering decisions made by the township. The zoning ordinance was created and is maintained by the New Britain Township Board of Supervisors. This zoning hearing board has no jurisdiction over the contents of the zoning ordinance. We ask that any concerns regarding the contents of the zoning ordinance be directed to the Board of Supervisors. Our procedures for tonight's hearing shall be as follows. Proceedings shall be conducted in a manner similar to that of a court proceeding, and all testimony shall be recorded by our court reporter. All affected parties shall have an opportunity to present factual testimony this evening, and all testimony must be given under oath. Only the facts and testimony presented to the board during this hearing will be considered. The board will first hear the applicant's presentation of their case, and the board expects the applicant to state the unnecessary hardship, how the proposal will not be detrimental to public welfare, and any other grounds the applicant believes support the application. The board will also hear from any other individuals who wish to become parties to this hearing. After the testimony has concluded, the board will hear from anyone who simply wishes to make a statement or ask a question that is relevant to the hearing. Depending on the length of the hearing, the board may or may not make a decision on the applications this evening. Our first hearing shall be for the application of 105 Sugarbush Court. And Mr. Gaiman, will you please read public notice and place the application on record?
The application of Brian and Louise Gallagher for the property located at 105 Sugarbush Court, New Britain Township, Bucks County, Pennsylvania, identified as tax map parcel number 26-15-124. Property is located in the RR Residential Zoning District. The property is improved with a detached single-family residential dwelling, use B1, as part of a planned residential development, PRD, use B11. The applicant seeks to construct an addition to the rear of the existing single-family detached dwelling. The applicant seeks a variance from the following sections of the New Britain Township zoning ordinance. A, from 27305.b.b11.c6 to allow an impervious surface ratio of 29.71%, where the existing ratio is 26.64%, and the maximum ratio permitted by right is 25%. And B, from 27305B11C6 to allow a rear yard setback of 31 feet 4 inches, where the required minimum setback is 40 feet.
Thank you. Mr. Walsh, will you please read the board exhibits?
Board exhibits for this hearing are as follows. Exhibit B1 is the application. Included with that application was a cover letter, an addendum outlining the relief requested, and a list of owners within 500 feet of the subject property. Exhibit B2 is a site location plan. It's one sheet prepared by Fluent Design Group, dated September 14th, 2022. Exhibit B3 is a letter to the Intelligencer forwarding public notice of the hearing. Exhibit B4 is the public notice that was just read into the record. Exhibit B5 is proof that the notice was published in the October 6th and October 13th, 2022 editions of the Intelligencer. Exhibit B6 is a letter to the applicants and their attorney providing the notice of this hearing. Exhibit B7 is the township's list of property owners that are within 500 feet of the subject property, as well as an aerial map of those lands. Exhibit B8 is an affidavit of mailing that notice of this hearing was mailed to the property owners listed on Exhibit B7. That notice was mailed on October 7th, 2022 by Ryan Gaiman. Exhibit B9 is an affidavit of posting that notice of this hearing was posted on the property on October 12th, 2022 at 10:50 a.m. by Ryan Gaiman. Lastly, Exhibit B10 is the Bucks County viewer map and aerial of the property.
Thank you.
Those are the board exhibits.
Thank you. And will you please explain our party status?
Sure. Anybody who is here for the 105 Sugar Bush, did I get that right? Yeah. Matter, you can, who's going to testify, you're certainly welcome to come up to the table. While you're doing that, the chair asked that I review how there is public participation at this hearing. Any zoning hearing, whoever's going to testify, you can sit and everybody else can go to front, back in the first row. And we
You
can
can go first row. It'll be fine.
That's okay. You don't have to shove around. If we're gonna hear from four,
Make them all fit in.
but whoever's gonna,
Use
I
the
don't think
chairs.
they'll all fit.
you're not gonna. All right, so this is not a town hall hearing. This is a quasi judicial board. All that means is the decision of this board is appealable directly to court, not to the supervisors or any other township body. As a result, there is a stenographer taking down everything that everyone says. Now we're recording every motion that everyone makes. And we don't just allow commentary like they would as supervisors. There are three ways you can be involved in this hearing. The first one is do nothing. You're not obligated to say anything. You are simply feel free. You can feel free to just sit and watch and listen. Number two, as the chair indicated, at the end of all of the testimony from the witnesses and presentation of all the evidence, there will be an opportunity for public comment. Public comment just simply requires you to state your name, where you live, what your comment is. The chair and the board reserve the right to limit comment if it becomes either repetitive or if it is more germane, or if it's not germane to the hearing, or if it's more pertinent to a different board, like if you should be making it to the supervisors or the planning commission or some other body. And the third way you can become involved in this hearing, excuse me, is if you can become, if you would like party status. Party status is something you have to ask for. It has to be granted. In order to grant it, you have to be aggrieved, or excuse me, you have to be affected by the application before the board. Affected basically means you own or you live, like rent, a property that is within a reasonable distance of the property that's subject to the application. So if you got a letter in the mail or a notice in the mail of this hearing, you're affected. If you didn't get a notice in the mail, that doesn't mean you're not affected. The board just will have to hear how you are affected if somebody objects to your request for party standing. If you live in Philadelphia, you are not affected. If you're just here for that, forget it. You're not going to get party status. Okay. So if there's anybody that would like party status based upon that type of description, we'd ask for it now. If not, we'll then move to the testimony portion of the hearing. Yes, sir. What's your name?
Dave Oman. OHMAN.
OHMAN. David, you said your first name was?
Yeah.
What's your address?
205.
Yep.
Holly. Holly. HOLLY.
Holly what?
Drive.
Okay, and that's Southot?
Yes.
And did you get a notice in mail this hearing?
Yes.
Okay.
And just to be clear, that's for the Sugar Bush Court case?
Yes.
Okay,
Yeah.
just to be sure. We have two on the agenda tonight, so I just want to be sure.
Okay.
Thank you.
All right, Mr. Griffin, is that
Yeah,
your name? Do you have any objection to Mr. Oman's request for party status?
I'm just trying to check if he was included on the notice. If he was, I have no objection.
I see his name right here. David and Denise Oman?
But I have no objection.
Okay, Mr. Oman, you'll be granted party status. When the appropriate time comes, I'll ask you if you have any questions of the applicants, any of their witnesses, and then there will be an opportunity for you to present your case in chief, if any. Okay?
Thank you.
You will also be subject to cross-examination, just so you're aware. Okay, thank you.
Good evening. My name is Andrew Griffin.
Okay.
I'm here on behalf of the applicant. I have with me this evening, in addition to the applicants, I also have the project architect, Jeff Stocklose, as well as the project general contractor, Joshua Cons. Essentially, we're in front of you this evening asking for what I would argue is de minimis zoning relief. We're asking to have a 360 square foot addition to the rear of the property. And then we're also asking to replace an existing patio area that's 311 square feet to replace that with a 438 square foot patio area. We're really doing that just to bring it flush with the addition. I'll have the architect go into it a little further, but we're asking for two variances. Just a variance to the impervious surface requirement, and then also a variance to the rear yard setback. So with that, I'd just like to call the architect, Jeff Stockers.
Okay, and is it Drumheiser?
Yes.
Lisa
Ready,
Drumheiser,
ready?
Ms. Drumheiser. Yes, please.
Do you swear the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Spell your name for the record, sir.
STOZKLOS.
Hey, Jeff, would you just say where you're employed and just give your qualifications and area of expertise for the board?
Sure. My name is Jeffrey Stockles. I work for Fluent Design Group LLC. We're in Langhorne, Pennsylvania. I am the senior designer there and have been there for about 8 years.
Okay, now in reviewing this property, would you just describe any unique or unusual physical characteristics of the lot of this ship?
Sure. When I started doing the zoning analysis and putting together the zoning information, I saw that the lot was more of like a trapezoidal shape. It has fairly large rear yard setbacks, and the existing house currently does not fit within the building envelope of the setbacks. It could be shifted a few feet to the front to fit more into the envelope, but as it currently exists, you wouldn't be able to put any kind of addition on the house without getting some kind of zoning relief.
Okay, so what effect, just in general, does the fact that the property is on a cul-de-sac, what effect does that have on the side yard setbacks and the front yard setback?
The setbacks on the front are fairly large, and it's radius, so it extends pretty far into the property. And the rear yard setback is fairly large compared to a lot of neighborhoods that we do additions on, and that sort of constrains the envelope that you can do any kind of work within.
Okay, and you mentioned that the house and the building envelope as it exists, it's currently non-conforming. How is it non-conforming with regard to the side yards?
Both both sides of the house actually extend into the side yard setback. The front seems to be within the setback, and the rear would be within the setback, and the sides touch both side yard setbacks.
Okay, and would you just go through it and let me actually just state this. I noticed when you went through the exhibits, you mentioned that B2 only had one page. I thought that we submitted two. If we didn't, I would like to just amend that exhibit to have a 2-page plan.
That's fine. You can submit the entirety as A1 if you would like, unless you obviously have pre-marked exhibits.
I have it pre-marked, so that's fine.
Okay. But maybe I only printed one. Okay. That's my bad. Thank you. I don't think you mailed them. I ran the email.
Now, Jeff, if you're looking at the second page of the plan, would you just describe basically what demolition and what addition is being added to the property?
So the rear of the property has a fairly large patio that extends a good portion of the existing rear of the house. We actually want to demolish a decent portion of that to make room for the addition. Currently, the kitchen is a very small kitchen, so we wanted to design an addition to expand the kitchen and give a little more habitable space.
Okay, and those areas that are being demolished, those are marked in red.
Yes, everything in red is what we plan to demolish.
And if you go back to the first page, we can just describe the location of the addition and how that would affect both the rear yard setback and the impervious surface calculation.
Sure, we're taking a portion, we're taking a portion of the impervious surface away because there was a portion of patio that is going where the current addition is going now. The addition will go to the rear, more towards the center of the house, and be complete within the side yard setbacks, but will extend past the current rear yard setback. And then we plan to put a patio next to the addition on the west side of the addition.
Okay, and just for the record, so we're clear, so the section of the ordinance requires a minimum of a 40-foot setback. We're here today, we're proposing a setback of 31 feet, 2 inches, correct?
I have a setback of 29.
Great.
29 foot.
Okay, for the rear side yard setback?
Yes.
Okay, and how about with regard to impervious surface? You mentioned that there's an existing non-conformity with regard to impervious surface.
Correct. The existing house, the existing property has 25.64% impervious, and 25% is allowed. And if you want to, with the addition and the proposed patio, go to 31.65%. So a 5% increase.
Okay, and in preparing these plans, did you have an opportunity to sort of?
Okay, wait a minute, just hold on a second. So can we get the right dimensional relief you're requesting? Because I don't think the addendum states it. This addendum has different setback and an impervious ratio you just read off than what the plan says.
29 foot 3.5 is where the proposed addition would be.
29 feet, 3.5 inches?
Correct.
Okay, and what was the impervious ratio you want to go up to?
The existing impervious was 26.64. And this was proposed with the addition would be 31.65.
Yeah, and I apologize for the confusion to the board. We had the plan sort of revised and made more viewable right as we submitted the application. And I think that's where the discrepancy came from.
You'd like to amend the application for those figures?
Correct.
That'll be granted. Okay.
Okay, and Jeff, just in preparing this plan, did you have an opportunity to sort of view the surrounding neighborhood?
We did look at some houses that are in the neighborhood, and there are a lot of houses in this neighborhood that have similar additions and similar decks and great rooms on the back of them.
Okay, so in your opinion, would this addition in any way alter the essential character of the surrounding neighborhood?
No.
Okay, would this addition in any way negatively impact neighboring properties' ability to use or later develop their properties?
No.
Okay. In your opinion, is this the minimum variance necessary to allow the applicants to have a usable addition at their property and also to continue to maintain patio space on the neighbor?
Yes.
Okay, all right. I have no further questions for the architect at this time.
Just because I can't read it. On the left side front of the house, what is the existing setback of that corner?
So on the left side, the setback varies between 12 feet and 22 feet, 8 inches, and that's an existing non-conformity for a portion of it.
So at its closest point, it's 12 feet?
Correct. And the reason for that is if you look at the frontage of the property, because it's on a cul-de-sac, that curvature of the cul-de-sac has to come back when you do the measurement, so it creates sort of this, you know, skewed side yard on that side.
Okay, my next question is, since it was a PRD, are you giving us the setback measurements of the PRD, or are you giving us the setbacks of just the B1 regular RR setbacks?
Oh, those are PRD.
So prior to submitting the application, I can actually just go ahead and offer this as applicant's exhibit 2. We had communication with the zoning officer where we confirmed what the setbacks would be and what the applicable dimensional standards were. And as a result of those discussions, we received the dimensional requirements for the PRD.
Okay.
Do you have a copy of the PRD plan itself?
I do not have a copy of the zoning.
Cedar
map.
Hill? No, not the zoning map. The record plan that's usually in a PRD, what happens is the PRD sets the criteria. It sets the dimensional variance. So what you're effectively getting is a variance from the plan. Townships don't, let me just finish. Townships don't necessarily follow in line. They change the dimensional requirements for the plan later on. So the requirements that you're seeking a variance from are from the ordinance, not necessarily the plan of whatever was approved, right?
That's correct. So we relied on the zoning officer in determining what the setback lines were based on the PRD ordinance and that those would be out.
Right, and I get that, but so just for the record, we don't have a copy of the PRD plan here.
That's correct.
Okay. Before you go on, A2 is a email message from Ryan Gaiman to Mr. Stockloss dated August 22nd, which is essentially summarizing what Mr. Griffin just presented to the board, where they got the dimensional relief they needed to seek.
Has there been any consideration for what we can do to offset the change in impervious?
We haven't really thought through what, we could do other than sort of the design we have right now. The house was already over the impervious surface. And we tried to reduce some of the existing patio and make it a little bit bigger on the one side. Patios can, probably be reduced if we need to.
Well, what's the stormwater management situation right now for the property, if you know? Is there any?
I don't think there's any right now.
Would any of your other witnesses know the answer to that question? It looks like the house was built in '88, so chances are there might not be.
To my knowledge, my name is Josh.
Please, we'll need to be
You
sworn.
need to be sworn.
The officer is very humble. You swear to testimony you're about to give, which is truth, the whole truth, and nothing but the truth. So help you God.
My name is Josh Kontz, Kontz. I'm the owner of 215 Build. We are the general contractor on this project. To my knowledge, there is no existing stormwater management in place at the property. But in my experience in these types of situations, we've done dry wells or rain gardens to facilitate in an area where we are over impervious. And that would be something that if this board approved the zoning relief, we could input in the plan.
Do you know the general slope of the property, Mr. Combs?
I do not. It's rather flat. I can't give you a degree, but it's fairly flat.
The board is, to follow up on the chair's question, typically said you would incorporate stormwater features like a seepage bed or a pit or something along those lines, like you referenced, to either produce a no impact or of any new impervious, or actually when you're over like this, where there have not been previous stormwater controls in place, to give yourself a de facto compliant ratio. So essentially infiltrate to take it to 20, what's the permitted 25%?
Correct.
So that is a condition for approval of any impervious surface ratio variance that the board has typically imposed. And are you suggesting that's something you could do?
Absolutely.
Okay.
That's something that's typical in a situation like this for us.
Okay.
And the homeowners and us are on the same page. performing that.
What's behind the house? Is it another house or, so they're surrounded by single family dwellings?
It is surrounded, yes, in both the rear and on both sides, with other single family dwellings.
There's mainly one property to the rear, but then there's another one that's just right at the left-hand corner, like the corner is just me, that's another property. And then there's a little bit of another property to the rear on the right. It's mainly just one that abuts it.
One other thing I wanted to clarify on the stormwater condition, I don't want to misstate or misrepresent that actually who will be reviewing that is not this board. It would be the township engineer and the township. There are multiple ways to skin the stormwater management cat, as this is more directed to the Gallaghers than anyone else. Sometimes you get credits for trees that are there. Sometimes you get credits if you plant more trees. But these all cost money. And I think, going into that with your eyes open I don't want to misstate that this is not a free lunch when you have to put a stormwater control in. But it's what, as Mr. Cron said, it's typically looked at in terms of how you offset runoff. Okay, sorry.
So I don't know if there's any other questions for the architect. If not, I'll move on to the next witness.
Scott, TJ?
No, sir.
Or I don't know if there's-
No.
Mr. Owen, do you have any questions for Mr.
Yeah,
Sawcloth?
I do. I'm not legal, I'm just, so I'm gonna be very simple. I guess my question is, how far is the addition actually coming out from that original house?
From the original house, it's coming out 20 feet.
And how far is the patio?
It's coming out to the end of the new addition, so it's coming out the same distance.
The total is 20 feet.
Correct.
And how far does the patio come out now?
The patio comes out currently about 10 feet.
And is that true? I guess is that correction that it's not 9 feet now, it's 11 feet difference? Is that what I understood from today's conversation?
It'll be a 9-foot setback. That was a clarification, correct?
Is it 9 foot, but now is it 11 foot?
No.
It'll be 29 feet.
It's a 9-foot relief. So they're asking for a 29-foot setback as opposed to a 31-foot setback. So it will be 29 feet, 3.5 inches from the rear property line.
Right, so which is 11 from requires 40. Is that right?
Well, that's
Yes. I
yes,
just understand.
that's
where-
correct.
Okay, so. And then another question I have is, you talk about the stormwater control, is the drainage. You know?
Yes.
And, yes, I'm in the corner behind them. I'm very much in favor of this project, 110%. But I just want to make sure the drainage, as in, every development, that it's, being a concern and taken care of. But I think the project's a wonderful project, and I think it's I support it as being probably the most effective person besides my neighbor from the drainage standpoint.
Okay,
And this is all.
understood. Any further questions?
No,
Thank you, Mr. Sucker.
thank you.
At this time, I'd like to call Joshua Cost.
He's already been sworn.
Okay. Would you just give your qualifications and where you're employed?
So I am the owner of 215 Build. We are based in Pendle, Pennsylvania. And we are a full service general contractor. We've been with this for 8 years.
Okay, and in working on this project, did you have an opportunity to review the surrounding neighborhood?
Yeah, so in conversation with the homeowner and the architect, trying to determine once we figured out that we were going to be requesting zoning relief, we looked at some aerial photography, we did some canvassing around the cul-de-sac and the adjoining streets, and there is no less than 16 within, I would say, 500 meters of this dwelling. There's 16 homes. I can give you the addresses for those as well that have similar or larger sized additions to their property in the same neighborhood. And due to the, again, the aforementioned irregular size of the lot, it's proving very difficult to build anything. That was suit the needs of the owners and, so that's why we're here.
Would you be able to facilitate the construction of any addition on this property without some form of zoning relief?
If we did, it would be very, very tiny and unworkable to the owner's needs. So in short, no,
And even then, you would need a variance from the impervious surface.
we would,
Okay.
yes.
In your opinion, is this property in any way going to alter the essential character of the surrounding neighborhood?
No, and in fact, I think it would go more in fitting with the character of the neighborhood, seeing as these other 16 neighbors have similar size additions and structures that they've already added on.
Okay, all right, I have no further questions for Mr. Thomas.
It'll be a one-story addition.
It will be a one story.
Made to complement the house.
Will have the same styling, the same exterior cladding, siding, same
Roof
style
pitch.
roof. Yes,
Is there anything in the rear yard between the back of the home, back of where the addition would be, and the rear yard, rear lot line?
there is not, other than a place set.
So there's no pool,
No.
no other permanent paver fixture that would impede potential stormwater design.
No, it's open grass.
Okay.
And in fact, this subject property is low lying compared to the properties in the rear. So they do receive additional water from other adjoining properties that are already existing.
In the place that's over grass or mulch,
In grass.
grass.
And what about the existing shed?
That is still remaining at this time. We propose, right.
Is the existing shed calculated into the impervious surface ratio?
It is.
Anything else? No, sir. Okay. No. Any further?
I have one more item.
Mr. Roman, do you have any questions, Mr. Con? No? Okay, hearing none.
Thank you.
Mr. Concher, any further witnesses? Mr.
I'd
Griffin?
just like to briefly call the property owner. And I'll just.
Will you be
offer-
sworn, please?
Ruth Letnier, do you swear the testimony about the gift, the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
Mr. Gallagher, when did you purchase this property?
2 years ago, almost to the day.
Does September 21st, 2020 sound correct?
Sure, yes.
And I'm just.
It was during COVID. Lucky you.
I'm offering this as A3 because I know it's a requirement that you have a.
Okay. A3 is the deed. It will be received.
Brian, who lives with you in the residence?
Myself, my wife Elise, and our 2 children.
Okay, and just generally, will you just summarize for the board why you're having this addition constructed?
Multitude of reasons. Whenever you have a growing family, especially little ones who like to run around, we're starting to run out of space. For that reason alone, we'd like to, as Josh and Jeff mentioned earlier, when we eat, we're trying to make the kitchen more food and friendly. So the addition will also allow us to build a kitchen into the addition rather than going into the home, into the dining room. In addition to that, I've been working from home a lot. So instead of working in my dark, dingy basement, this will also allow me to work in privacy upstairs in a room with plenty of light. In addition to that, this is just going to be a situation for our family to really, truly enjoy the house. I think the way that it was meant to be. So, multiple reasons.
Now, once the public notices went out on your application, did you have an opportunity to talk to any of the surrounding neighboring property owners about the application?
I did, yes, I talked to everybody in my cul-de-sac. Everybody was on board with it. Half the houses in my cul-de-sac have additions as well, so they're in full support of it. They have different style houses. And so what we've done was trying to adapt essentially how they've done theirs to model it onto our house.
Okay, I have nothing further.
Mr. Oman, any questions of Mr. Gallagher?
No, I just know it's gonna be done in good taste and I visually is gonna be the one to be able to watch it more than anybody else, so I'm in support of it.
Okay. Anything?
Mr. Gallagher, what is your proposed patio? Is that, will be that concrete slab? Is that pavers? What is it supposed to be?
We're still open to that, most likely pavers or stamped concrete, I think are the two proposed options.
Thank you, Mr. Gallagher. Roman, do you have any, or Mr. Quinn, do you have any further witnesses?
No.
No, Mr. Roman, do you have anything else you'd like to add?
Thank you very much. for your time.
Okay, thank you. Anyone else for public comment? Hearing none? Okay, go off the record.
We'll go off the record. Gentlemen, thank you for your patience. We're gonna go back on the record.
The board has deliberated, and if the board is of a mind, the recommended motion would be to grant the amended relief, as stated in the revised plans. Relief will be conditioned upon the two following. One, the approval is subject to the definitive plan and as laid out in those plans. And two, stormwater management improvements will be installed as approved by the township and the township's engineer that would produce a de facto compliant ratio of 25%.
Do I have a motion?
I'll make that motion.
Do I have a second?
Second.
Any discussion? All those in favor?
Aye.
Aye.
Okay, you have relief, conditional relief. You'll get a written decision within 45 days of tonight. Your attorney can explain to you the impact and the implications of all of that. Mr. Omen, because you're a party, you'll get a decision mailed to you as well. Okay, this hearing's concluded. Thank you all for coming.
Thank you. Good night.
Good luck with your project.
And we can step right up. Next hearing on the agenda this evening will be for that of 1100 Horizon Circle. Mr. Gaiman, will you please read public notice, place the application on record?
Application of Protect Hotel and Chalfon Adult Daycare Inc. for the property located at 1100 Horizon Circle, Suite 102, New Britain Township, Bucks County, Pennsylvania. Identified as tax map parcel 26-5-47-8. Property is located in the C3 Commercial Zoning District. The property is improved with a non-residential building. The applicant proposed to conduct an adult daycare use C6 at the property. The applicant seek variances from the following sections within the Britain Township zoning limits. A, section 27-305 C, C6, B2, requiring that a minimum of 20% of the property be used for passive recreation. B, from section 27-305 C, C6, and 3, requiring that security provisions including a fence along any lot line abutting an arterial or collector street be installed to protect residents and secure the property. C, from section 27-305 C, B6, B6, limiting the hours of operation to Monday through Saturday, 7 a.m. to 6 p.m. D, from section 27-305 C, C6E, requiring the operator to obtain a license from the Pennsylvania Department of Aging. And E, from section 27-305 C, C6F, requiring facilities for passenger loading and unloading, including a drop-off area and automobile stacking.
Very good. Thank you. Mr. Walsh, will you please read board exhibits?
These are the board exhibits. Exhibit B1 is the zoning hearing board application. Included with the application was a lease agreement dated July 21st, 2022, with the applicant listed as tenant. A list of provided services that will be conducted by the proposed use, and a Commonwealth of Pennsylvania Department of Aging applications for a license to conduct it. Exhibit B2 is a zoning officer determination dated August 12th, 2022. Exhibit B3 is a site plan. It's one sheet. It's prepared by Bach and Clark surveyors, and it's from 2008. Exhibit B4 is a letter to the intelligencer providing notice for publication for this hearing. Exhibit B5 is the public notice that was just read into the record. Exhibit B5 is proof that that notice was published in the October 6th and October 13th, 2022 editions of the Intelligencer. Exhibit B7 is a letter to the applicant providing the notice of this hearing. Exhibit B8 is the township's list of property owners of record that are within 500 feet of this property and an aerial map showing the location. Exhibit B9 is affidavit of mailing that notice of this hearing was mailed to the property owners listed on Exhibit B8. That notice was mailed on October 7th, 2022 by Ryan Gaiman. Exhibit B10 is an affidavit of posting that notice of this hearing was posted on the property on October 12th, 2022 at 11:11 a.m. by Ryan Gaiman. Lastly, Exhibit B11 is the Bucks County viewer and map and aerial of the property. I note for the record there is only one other individual in the audience. Were you here earlier, sir, when I went through my summary of involvement in the hearing, meaning, okay, so do you need me to repeat that?
No.
Okay, are you here as a witness or are you here as an observer?
He's a partner of the business.
Okay, so you're-
a partner.
You're here as part of the applicant. Karen. Okay. So for the record, the only individuals in the room are the parties of the board and no other residents.
And will you be testifying this evening? You will?
If needed.
Oh, if needed? Okay.
So why don't we
why
swear
don't we-
both these gentlemen?
You please raise your right hand. You swear testimony you should have to give, the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you very much.
Are you Mr. Patel?
Yes.
All right. Pritesh Patel, right?
Pritesh Patel. Yes.
And sir, what's your name?
Sahil Patel,
Could you spell your first name?
SAHIL,
S-E-H-A.
SA.
Oh, I'm sorry, S-A-H-I-L?
Yeah.
Okay. Okay,
Floor is yours.
All right. So my name is Pritesh Patel. I live at 1377 Memorial Drive, Warwick, which is 20 minutes drive from this location. We are planning to open a business, adult daycare center. We have like 4 partners. Sahil Patel is one of the partner. Other 2 partner is not available today to come in this meeting. We believe that location is compliant with all the state requirement. We have also hired a state consultant, to make sure we have appropriate procedure in place to comply with all policies required for the licensing applications. We'll make sure that we have all that other facilities like medical service, family relief, nutritional service, and other as we required, the state requirement services appropriately in place for proper quality care of that adult and client. So we are here to seeking that this comment that we have denied in a zoning permit. The first one is the minimum 20% sites shall be suitable and developed for passive recreational area. And we provided that as per state licensing requirement. The only requirement is indoor floor plan and other additional space, which is like in indoor activities, indoor entertainment center, prayer room or quiet room, which will be in place as a part of the state licensing application.
you said, well, okay, so hold on a sec. So on that, you said that's indoor?
Yes.
Okay, so the ordinance,
So it's 11, state requirement is 11.52 indoor floor plan and other space.
okay, so it's a little unclear to me when I saw this. It says a minimum of 20% of the site shall be suitable and developed for passive recreation. So to me, if I read that broadly, that could mean outside or inside. Okay, site means your entire property.
Oh, okay.
Okay, so I don't know how what the township intended there.
I was intended that I thought is outdoor, but we will have indoor activity which include game room, entertainment room, prayer room, quiet room, which will be in place as a part of our state requirement that have some additional apart from these township requirement, we will be in compliance with that as well.
Do you know the size of that? All those recreational rooms in the building that you'll be using?
There are like 8 to 9 rooms in the current leasing property, which will be provided as a separate room with that. So we have like pretty much, we will maybe require minor modification as a part of the application, but other than that, I don't have the exact size of the room, but there are like at least 9 to 10 rooms currently in that location, which will be provided different activity for that passive recreational area.
And you said there were what again? Game room and
Are you
what?
saying passive recreational area?
Yes,
Yes.
you said it was a game room.
Game room, quiet room, one is entertainment room and prayer room.
Is it the entire building or just a particular
Just the
suite?
unit 1 or 2.
Just, you know.
And
And-
we are, the other unit is also available, but we are the part of like our initial new business, we are starting research, and if everything work out good, we might go with the next available building as well.
All right,
Which we already have talked with the owner.
all right, so unit 102 is 4,600 square feet?
Yeah.
Yeah.
All right, so 20% of that is what, 920 square feet?
Yeah, it will be more than, definitely more than that, recreational area in the.
So of the 4,600 square feet that you're leasing, more than 920 feet of it will be composed of that game room, quiet room, entertainment room, and prayer room.
I would definitely say that.
Do you have, as part of your lease, the ability to use any of the outside areas exclusively for recreation?
No, outside area will be only for the parking.
Looking at your plan, there doesn't appear to be much outside area to begin with.
Yeah, there is no available any outdoor area for any recreation activity.
Okay. Sorry.
The second one, the fencing requirement, there will be no any outdoor activity as part of our procedure. We will make sure that all client and customer will be stay inside the building throughout the service, from 8 to 3. That will be the normal service for the client. We will have like hour before and hour after that. So the business hours will be most likely 7 to 5. So that would also cover that number 3 comment for that denial letter.
Okay, can we go back to the fence for a second?
Yeah, sure.
So the only street this abuts is County Line Road, and there's no streets on the sides of the rear, right?
It's like, yeah.
I'm
So
at,
there's no access to the county line.
okay, well, it has Horizon Circle in the back. That's technically a street too. The cul-de-sac where you enter,
Correct, yeah.
but the question, I guess, and you may not know the answers, maybe Mr. Gaiman knows the answer to this. The zoning ordinance says this includes a fence along any line abutting an arterial or collector street. Now, I can't imagine Horizon Circle is an arterial or collector street. The only one I would think is County Line Road. Are fences allowed in the front yard?
Yes,
What under, they are?
oh, residential fences, I'm not sure about commercials.
Okay. So this ordinance might be requiring something that's not even allowed?
I don't know that there is anything that prohibits fences.
In the front yard? We don't know that? Okay.
Mm-hmm.
I know we've had residential applications where if you want to put a fence in the front yard, you need a variance for it. But that doesn't apply to you, but it's my common understanding of zoning ordinances that fences are not usually typically allowed in the front yard. So I think we should get clarification on that. Do you happen to know, Mr. Gretsch?
When you're saying front yard, Mr. Walsh, what are you referring to? You're
Front of the
referring-
yard that's abuts, the only front yard that abuts a collector street.
Would be the yard next to County Line Road?
Yeah, and any yard, the abutting a street is considered a front yard, but in this case, Horizon Circle is not one, so that is not requiring a fence.
Am I correct that there's no entry or exit into the parking area from County Line Road to this property?
Based on this plan,
No,
That's what I'm looking
there's no entry for that.
it's just from Horizon Circle, right?
There is one entry, but it's like for the next building and then you can come through there, but it's not right front of that unit. It's a little bit further away from that unit.
Like, and
Yes.
so if you wanna, if you're coming from the County Line Road, it's only one way entry right next to the Grandview Hospital, like the outpatient center. Then you can go inside and make a turn and go to this parking lot, but there is no particular, for this 1 or 2 parking lot, there is no particular entry from the County Line Road. And you cannot go out from the parking lot. So if you are in the parking lot, it is secure area, like you cannot get out to the County Line Road or get in from the County Line Road.
It's only one way entry.
And would there be a setback requirement for a fence off of County Line Road?
Couldn't be in the right of way.
Right, it would likely be pretty significant,
Mhm.
so.
Which would put it
Doesn't look that wide.
right through the 50, well, this plan is from 08, so I
It would
don't,
probably be in the parking lot.
it would be,
It would probably be in the parking lot.
looks like
Exactly.
the 50-yard setback line goes right through the parking lot.
Yeah.
Okay, but for purposes of our record,
Then there's the fence moot.
yeah, essentially, the only street of that classification that abuts any portion of this property is that front yard along County Line Road, correct? All right, and there's no access from County Line Road, vehicular, there's a sidewalk in front, right, but there's no.
No, you cannot do on sidewalk, it's like very high rise, like.
It's like a slopey hill.
The slowly, the hill thing, you cannot like, do on sidewalk.
Oh, there's a retaining wall?
Yeah, like, not wall, but it's like.
It's like a little bit.
Elevator.
Egress or something.
It's like main.
Oh, I see it, okay.
Yeah.
I see it, okay, thank you, sir, Mr. For the record,
It's
Mr.
entrance.
Cox had, the chair is showing me, there's a right turn only entrance.
It's entrance, not exit.
Entrance, it's a right turn only entrance.
yes.
Clearly that photo is more recent than this plan. And this plan probably predates when County Line Road was
Mhm.
Wide.
widened recently.
Yeah.
Okay. Okay, thank you. Go ahead.
Okay, number 3, the hours of operation, we will be compliant with that Monday to Saturday. It would be between 7 to 5. As I mentioned, we will keep it open for cleaning or other activity, but other than that, we are not going outside of that department. We're going to send that to Saturday.
So you said it's 7 to 5, but you also said it's 8 to 3 for the,
So for the client is only 8 to 3.
okay. Okay,
Number 2, the applicant for the adult daycare center provide a license from the Pennsylvania Department of Aging and Compliance. In order to apply for that Pennsylvania license application, I need a township zoning permit. That's the requirement for the state license application. And it has to be compliance with all ADA and other requirements that I have to be also make sure that it's compliant with that as well.
okay, so this is more of a,
I cannot apply for the license without the zoning permit.
no, I understand, but this is really not a variance request, okay, in per se, it's more of a variance would essentially, yeah, it's correct. The
Okay.
variance would relieve you of the obligation to get that. You're not getting that variance, okay? But from a sequencing or timing perspective, you can have a not signaling what the board is gonna do, but you could get relief subject to the decision of the board, and you would not get a subsequent zoning permit. You would have a decision of the board that says the use is approved with whatever relief is attached to it, subject to you obtaining a zoning permit, a zoning and use permit, which is the final stage of the whole process. Okay. So if you want to withdraw that one, I'm not going to tell you what to do, but that's not even something that the board could give a variance from, because it's a
Above our
regulatory,
pay grade.
it's a regulatory requirement for a state agency. So the board's essentially without jurisdiction to grant a variance from that.
And the last one is the passenger loading and unloading. As a part of our daycare center, we will provide a transportation to every customer. So they would not driving to the location. We will probably need only the employee parking, about 8 to 10, and we have more than enough parking for this facility. So far.
Well, all right, so let me back up. How many clients do you anticipate serving at any one time?
So it's gonna be also that's based on the square footage and all that. So maximum, I believe it's gonna be 35 to 40. Client will be allowed in this facility.
Well, is that what's allowed by the square footage, or what?
It is like as a state requirement, there is, I think, 40 to 50 square feet per individual or something like that. So that that would be play in consideration when we apply for the state license application, and they will have the number listed in there. But I would say not more than 50 people as per this 4,600.
Well, my question wasn't what does the state allow based upon square foot? 1 second. My question was, what do you guys plan on doing?
We have to comply with the state, so we will do like maximum 50 people.
Which is already higher than the number you just said the state would allow you.
We will plan with that 50 people, but then we will compliance with the state number of people. If says that no, we cannot have more than 40, then we will stick with the 40 people.
But you don't know what that requirement is.
I don't know the exact square feet, but I believe it's 50 square feet per individual for the state requirement.
And how many square feet are in the building? In the unit?
4,600.
4,600. Okay, so we have to be able to do some math here. Okay.
See,
So in regards to the parking, you're saying that the employee is going to provide the transportation. Is there going to be a shuttle bus?
We will have a different LLC as a transportation LLC, and that will provide a transportation like pickup and drop off service to all clients.
So then where there will be a loading and unloading area provided for that shuttle bus?
Yes.
Because your statement was that the existing parking spaces would suffice. But if there's a shuttle bus, depending on the size, that parking space might not work. And you would have to have an area you would have to have a designated area for that shuttle bus to pull up, unload and unload passengers.
Right.
You know, that safe loading area is, I believe, what it's referring, as opposed to the people navigating through parked employee cars.
Mhm.
No, we will have that loading and unloading area with wheelchair accessible.
well, I guess that's the board's point is you have where you need a definitive plan that shows.
We have already the wheelchair access in front of the building, in the parking.
There is one on the left side, there's a whole parking on the left side of the building. It's available, and on the front side, the whole parking lot is empty.
Well, parking spaces available is different than a loading and unloading area. Okay, that it's an area that's reserved, to my understanding, that is specifically for loading and unloading, where cars cannot park, and there should be nothing other than foot traffic.
Mhm.
Yeah.
Is that
We will designate one of the area because there are three on the three sides that are parking, on the back side, on the front side, on the sideway. So there are three side of the building of one or two has a parking, and it's some more than enough parking. Even if every employee is bringing the car, there's still like more than enough parking on the one or two
Okay.
side.
How many employees do you plan on having at any one time, maximum?
It all depends, like how many will get, like this is like our startup business, so we don't know.
Okay, well, just let me stop. We don't know, and it all depends are not answers that get relief.
So
Okay.
maximum, I would say 8 to 10 employees.
Okay. So you have an 8 to 10 employee parking need. You might not have a parking space issue based upon what the zoning ordinance requires, but to the chair's point, this plan does not show anywhere there would be a drop-off area. It doesn't show anywhere cars would stack. It doesn't also show where your entrance would be. Okay, and where the buses would come in and where the clients would come in and out. You've represented to the board that you're going to do all this, but you're the tenant. We don't, until we know that the landlord has committed to that to be allowed. That's a little premature
Mhm.
to say, oh, yes, we're going to do all that, but there's no definitive plan that shows that. We would need the definitive plan that said, yes, the landlord has approved this reconfiguration of the parking lot.
We can confirm with the landlord and provide that additional document for that specific unloading and loading for the clients. Yeah, we can create that and follow up with the landlord and provide that this is gonna be the specific location for loading and unload in the parking lot.
okay? And just for due diligence, and I'm not an expert, you have to also have to understand that you can remove parking spaces from the plan. Okay, because the parking spaces are sized based on occupancy use of the property. Maybe there's extra. I don't know. Maybe it was tight when it went in. I don't know. That has to be part of the consideration as well. So in that, that was part of the original, you know, the original permitting process.
Yeah, I think originally it was an office building, so they probably need more parking space than these, but yes, yeah, we can have something in place, make sure this is the loading and unloading area and provide that.
Is there a state mandate in a licensing process that says a ratio of employees to, in this case, customers?
There's a specific
Clients.
requirement for like nursing and caregivers and
Okay.
for serving the foods and hot and cold, like breakfast and meal and all the requirement in that too. So we will have to comply with that.
Okay, so above my pay grade, none of my business, but you seem to be very well versed in a lot of these requirements, and you said we asked the number of employees. So I just want to hear from you that if it's mandated by the state, then again, above my pay grade,
Yeah, there are some
you're
requirements.
obligated to comply.
Yeah.
Okay. Any other questions?
Mr. Gress, you have any questions as a witness?
I do. When, if, at the board's permission. Are you done with your questions?
I'm SEI. Are you done?
We're done for now, yeah.
You're up.
Mr. Chair, thank you. Mr. Patel, I want to go back to your discussion of the minimum 20% of the site should be suitable and developed for passive recreation. Am I correct that it is not part of your plan to add any outdoor recreation facilities of any kind to the current site? Is that right?
Correct.
It's also not part of your plan to include any sort of outdoor sitting areas or walking paths. Is that also correct? Correct. And it is not part of your plan to, certainly if you're not going to build those things, you wouldn't also be planning on enclosing those things with a 6-foot fence. Am I right? Okay. Am I correct, based upon the plan that I've seen and the character of this plot of land, there would be room on this plot of land if you had the landlord's agreement to include all of those things if they wanted to, isn't there?
There is a space available back side of that building. It's needed, and with landlord agreement, we can create that.
But it's currently not part of your plan, is that right?
Currently, it's not.
All right. And including those things I just asked about is not part of your current business plan as you see it today, is that right?
Correct.
Okay. Mr. Patel, can you tell me, or do you know what sort of business was hosted or occurred in the suite that you're renting before you rented it? What was it before?
I think it was a office building from life insurance company, Prudential or something.
Oh.
It was there, that's what I'm guessing, but
Right.
it looks like office building.
Okay. And am I also correct that there's a medical office in the building?
There is a medical office, yes, in the rear of that building.
Okay.
Yes.
There's also a travel office, a travel agent in the building, right? Or there was, do you know?
I'm not aware of, unless if there is in the back of the other building in there.
If I'm looking at the building and you have the plan in front of you, where in the building that we're looking at is unit 102 that you're discussing?
It was like pretty all far away, the last unit in the building.
Last unit away from the entrance, so on the back side, if you will?
In the county line, in the corner one, the last unit.
Okay, so you're talking about essentially the corner of the unit that faces west?
Yeah.
The border of the property with County Line Road, am I correct that there's no fence there currently?
Correct, there is no fencing.
Am I also correct that on County Line Road, there is a sidewalk area?
I'm not 100% sure, but I believe there is no sidewalk on the county line road.
If I were to show you an overhead photograph.
There is now.
There is now,
When they expanded it, they put one.
yeah, because
Probably
Yeah,
came
I'm not gonna-
further by.
I'm not holding you responsible for knowing or not knowing whether there was a sidewalk there. I just wanted to know if you did.
Okay.
Am I correct that there's no barrier between the sidewalk and the parking lot other than, as you previously testified, a small incline?
Correct.
Am I correct then that if I wanted to, I could walk from the parking lot to the sidewalk and vice versa without any significant problem?
Yeah.
Would you also agree with me that anybody could walk, any business invitee of yours could walk from the sidewalk, I'm sorry, from the parking lot up to the sidewalk? And you'd agree with me that it's not part of your plan as submitted to this board to place any sort of barrier or fence in that area to prevent your clients from walking up onto the sidewalk or onto County Line Road, is that right?
Client will be in the building. We will make sure that they don't go outside. That's gonna be a part of our procedure, that they should have to stay inside the facility, and it will be our responsibility that they should not go outside of that facility.
Okay, so the whole point of your business is that the residents and the clients that you have, not residents, I apologize. The clients that you have will remain inside at all times. They'll be fed inside, they'll get their recreation inside, and then they'll leave, they'll get back in the bus and leave. Okay. And am I correct that it's your belief and your testimony that the currently developed handicap spots in the parking lot are sufficient for the loading and unloading of your clients?
That's my knowledge, yes. But if needed, we can change according to the state licensing. They will come and inspect that before even we get the licensing, and we will have to make sure we comply with this.
But I'm also correct that it is not currently your plan or your proposal to do anything like a drop-off area or an automobile stacking lane, is it?
That is not in the plan, but again, like, we did not even get through the licensing from the state, and we have to create that plan if needed to make it compliant with that.
And based upon, have you even had discussions with the landlord about any alteration of the parking lot to suit an automobile stacking lane or a drop-off area?
There was some discussion that if it's state required, we might need some alteration in that, and he's okay with that, to do that for 1 or 2 parking bus needed based on depending on the client, and we can have a dedicated location for that.
But only if it's state required.
Yes.
The fact that it's required by the zoning ordinance.
No, we have to make sure even zoning ordinance too, yes.
Well, then what variance are you asking for then?
Oh, I thought that this is only for the parking space, and that's what I was under impression that, that it was like the parking space for the client, which will not have it. We will gonna provide a transportation, and they will be coming to that,
this is-
transportation bond. So,
This doesn't, section that Mr. Gresh is referring to is what the board was talking about earlier. It's not the parking spaces themselves,
Yes.
but the drive up, the drop off, kind of like what you would see at a school bus in front of the school.
Mr. Patel, does your partnership group or the business that you're here to represent, does it own any other adult daycare facilities such as this?
No,
You don't operate any now. This is a new
this
venture
is
for
the
you.
new business for.
And would you agree with me that a number of other types of businesses could be run out of the facility that you have a lease for without any significant alterations to the current property, right?
I'm not aware of that. So
Well,
could be possible.
like an insurance office, for example, right? You're just not in the insurance business, right? Okay. You could run, let's say, a small law office out of that space, couldn't you?
Mhm.
Yes. You could run you could have another medical office in that space, couldn't you?
I'm not sure of that.
Do you have any reason to doubt that?
If he, well, he doesn't, I don't think he can, he's not qualified to answer any of those questions. He doesn't know that.
I don't know about medical business, so I don't. know.
And I'm sorry, sir, Mr. Patel, what were the proposed hours of operation for your facility?
It would be 7 to 5.
On what days of the week?
Monday to Saturday.
One question I had, Mr. Patel, as a follow-up, something Mr. Gresh raised, is that do you need a separate plan, site plan, for your state permitting application process?
Yes, because we have to make sure it's all ADA compliance, loading and unloading, wheelchair accessible. Make sure we have a bathroom, shower, it's also ADA available, and all that. Also, we need all that included into the PST license application.
So that plan is effectively what this board would also, from a definitive plan standpoint, need to see. Because most of these requirements would probably be addressed in that definitive plan. This plan from 08 is not definitive.
We have a consultant hired for the PA licensing application, and she's working with us. But this was like initial phase of our business. This is like first thing we apply to the township to get the zoning permit, because we thought that that's the first thing we need in order to get the state licensing, and then we're gonna continue with our plan. Once we get these, then we can continue with our licensing application and modification of.
No, I understand the process. And I understand you need to be able to show something on prior approval to go to the state, but there are some things that are state requirements. There are some things that are township zoning use. Your use is permitted by right, but it's required to meet these items. Now, some of these are going to be addressed in that state process. That's one thing, but if the state doesn't mention fences, if the state doesn't talk about passive recreation space, those are township requirements. So a definitive plan, as Mr. Gresh alluded to, you don't have, it's not part of your plan currently to do those things.
We can create that like definitive plan for based on the state requirement, and we can submit to the county.
I have an important question. With that said, with your lack of knowledge about the process, did anyone give you any guidance that a plan would be recommended in order to facilitate this zoning application?
No, I did not get any of that.
Not from the zoning office,
No, not that.
the supervisors? Did anyone from anyone in the township contact you and give you that advice? Okay. So, okay.
Well,
I think it's hard for us to really consider your plan because there's a lot of what ifs and things that we can't per se answer without a definitive plan.
I couldn't have said it better. I think if you were to be able to, we presented a lot of evidence here. You could allow the board to hold the hearing open and you could prepare this plan. Okay. And then when you're ready, come back and present it, allow Mr. Gresh to question it, because I believe the township is opposing your application with all the conditions of all the variances you want. But maybe that plan would not only be definitive and allow the board that rule, but it might address other concerns. I don't know. I don't speak for the township. You'd have to speak to them. But to Mr. Fisher's point, it's the board can only rule on definitive plans, not what ifs, maybes, whatever the state allows. You know, it needs to know what's the site going to look like within a reasonable degree of certainty, and that's just, you don't have that.
Right, we need to know if it can be done and if you have permission to do those things.
That's a key point. If you say, yeah, we're going to do all this stuff, and then the landlord turns around and says, no, that's a problem.
Understood. Yeah.
So
then,
what would you like to do?
Yeah, I think I'm okay with that. If I talk with him, like if we can go ahead and continue, like keep it open.
He's here. You can put that on the record and
Like we can keep it open, and then we have a definitive plan from our consultant for our licensing application and can submit to the township.
Yeah.
all right. Mr. Gresh, would you have any objection to that?
With the hope that the applicant could certainly come closer in compliance with the zoning ordinance during that interim, I have no objection to the plan.
Well, to continuing the hearing until they can submit one.
Yes.
Yeah. We're not asking you to prejudge what the plan says. That will remain open until you actually get it done. Now, the board's next meeting is when?
November 17th, I think I read.
My wife's gonna kill me. That's her birthday.
Do we have a waiver?
No, we would put it on the record right now.
Provided they can get them, I guess.
Yeah, if,
Within a
how
month,
long do
less
you
than a month.
believe it would take you to get a site plan,
A current site plan.
a current one, not one from 2008? You might need a couple of months,
Right, that shows all these
and you might need
plans,
the
the bus drop
landlord,
off area, I guess.
right, and you may need to, and we would like to know that the board would like to know the landlord has also reviewed and approved. So I think if we were to schedule this hearing for November 17th, that might not give you enough time.
I assume the board would like to see a current plan and a proposed plan.
Well, we wanted to see a definitive plan. If it shows existing conditions versus what your proposal is, I mean, that could be on one sheet.
I don't believe that I'm out of with it. That is not always the case. We don't always have an existing plan and a proposed plan.
They can be one and the
Oftentimes, we
same.
just have one. Okay, that is it's either all encompassing with dotted lines, if you will, or just a proposed plan, depending on the nature, scope, and
Right.
expertise hired by the
What
applicant.
we don't want is a hand-drawn plan. Okay,
Not in this
what
case.
no, well, because what you're looking, what the plan needs to show or is going to essentially require some kind of traffic analysis of how the drop off will flow through the lot.
Mhm.
Mhm.
Okay. Just hand drawing it on a piece of graph paper, which removes handicap spaces, is not going to work. So you'll need some degree of professional assistance to prepare that. So that's why I'm thinking, if you've only engaged a consultant, you might have to work on engaging a professional to assist with that plan, to talk to the landlord. So if we were to give you 60 days, which would, when's December, right?
December 15th.
December 15th. If you're not ready by then, you can let Mr. Gaiman know, and we will push you out even further until you're ready. But we won't push it out indefinitely. Okay. All right, so that being said, we'll keep the record open. We're gonna adjourn this hearing on the record until December 15th.
Mhm.
7 PM here in this room, and you're agreeable to that schedule. That's beyond that. You're entitled to have, once you open this hearing, you're entitled to have another hearing within 45 days of this one. December 15th is not 45 days, so you're waiving that requirement, right? Say that loud enough so I can hear you and so she can hear you. Okay. Okay, you had a question?
If we have planned like earlier, then can I schedule in November or no?
No. I have to put something definitive on the record
Mhm.
right now. I'm sorry about that,
No, it's good.
But
Okay.
it's a very good question.
but it is a good question.
In business parlance, that would be the question.
Mhm.
All right, do you have clear direction from the board on what they are looking for?
Yes.
If you have any further questions, you can refer them to Mr. Gaiman. The next time you'll see the board, you can't address us directly, but you could ask a question to Mr. Gaiman, he can get it to me. Because the board's only allowed to deal with you in this open forum.
Okay.
Okay?
Mhm.
All right, Mr. Gresham, anything further?
Nothing.
From the township? Okay, thank you both, gentlemen. Good luck.
Thank
See you in a
you.
couple of
Thank you.
months.
Everyone, this concludes the New Britain Township October zoning hearing board meeting at
We're out.
26.
Feel free
How about
to
that?
return to your.
This is-
Your clothes on the record.